Thank you, Tim, for your interesting presentation on the activity in West Virginia, Ohio, and Pennsylvania. Next up, for the Ohio Oil and Gas Association legal report, is Attorney Mitchell Tobias. Mitch is an associate at Voorhees in Columbus office, a member of the litigation group. He is also a member of the Ohio Bar Association, the Columbus Bar Association, and the Federal Bar Association. That's a lot of bars. Not those kind of bars, though. Prior to joining Voorhees, Mitch was a practicing mechanical engineer. Please welcome to the stage Mitch Tobias.
Thank you. Good morning, everyone. Here today to talk about some of the notable cases that came out in the past year from Ohio courts and give the annual oil and gas legal update. The cases we'll talk about today generally fall into about 5 categories. We've got some Dormant Mineral Act cases, a few one key royalty and post-production cost case that turned out to be maybe a bit of a surprise with the decision that we maybe didn't get there. Several lease validity cases, a few of the newer pipeline cases that are coming up now, and then we have a couple miscellaneous cases that at the end that don't fall into some of these other categories. Starting off with the big Dormant Mineral Act cases this year. September 15th, 2016, the Ohio Supreme Court released several decisions, including the lead case as far as guidance, Corbin v. Chesapeake Exploration. A couple other cases came out that day, the Walker case and the Albanese case, applying Corbin to specific facts of what would constitute savings events and how to apply the Dormant Mineral Act. And several other cases were decided with just opinions applying Corbin. Corbin came to the Ohio Supreme Court on a certified question from one of the Ohio Federal District Courts. 2 questions were presented in Corbin. One, does the 2006 version or the 1989 version of the Dormant Mineral Act apply to claims asserted after 2006, where there's allegations that mineral rights automatically vested in the surface owner prior to 2006? Long certified question. Second question, is the payment of a delay rental during the primary term of an oil and gas lease a title transaction and therefore a savings event under the DMA? Coming out of that, the court had really 3 key holdings. First key holding that came out of Corbin was that the 1989 version of the DMA was not self-executing. It did not automatically transfer ownership of dormant mineral rights to the surface owner of the property by operation of law. That question had been open for quite some time. There were legal opinions going each way. This is where the Ohio Supreme Court decided it for all of us. In reaching that conclusion, the Supreme Court found important that the 1980 law did not use the word extinguish, and it didn't declare dormant mineral interest null and void. Very, very technical question looking at the specific language of the law. The court said the 1989 law provided the dormant mineral interest, quote, shall be deemed abandoned and vested in the owner of the surface. Because of those specific words used, the court decided that was just an evidentiary presumption. It didn't really do anything other than provide a burden shift for the person claiming that the rights had transferred. And this was the court's language, by providing a conclusive presumption that the mineral interest had been abandoned in favor of the surface owner if the holder failed to take timely action to preserve it. The legislature provided an effective method of terminating abandoned mineral rights through a quiet title action. So the court said, not self-executing, you still had to bring a quiet title action, but it shifted the burden of proof, so you didn't have to go out and find evidence for some long period of time that may not exist. Just created a presumption. After the court started with that decision, it followed with the second key holding. The 2006 version of the Dormant Mineral Act applies to all claims to abandon dormant mineral rights asserted after the effective date of the law, June 30, 2006, and the 2006 version specifies the procedure that a surface owner is required to follow. Follows pretty easily from the first holding. And then reaching the last certified question, third key holding from Corbin, the payment of a delay rental during the primary term of an oil and gas lease does not qualify as a savings event under the DMA. Using the court's language, the payment of a delay rental is not a savings event, either under the 1989 DMA or the 2006 version, because it's not a title transaction that has been filed or recorded in the office of the county recorder of the county in which the lands are located as required by the statute. Just a textual application of the 2006 law. So that was really the three key holdings. I think many people were waiting for that decision to come out. It took a while to come out. And one of the other cases that came out that day, just as an aside, the Walker v. Chandrick Now case, that was actually appealed to the United States Supreme Court. And just about less than 2 months ago, the U.S. Supreme Court denied hearing that appeal. So this is currently the law of Ohio. The next category, a case that I think a bunch of people anticipated and maybe turned out to be a bit of a letdown for those of us that were looking for guidance from the Ohio Supreme Court, was Lutz v. Chesapeake, Appalachia. Decided on November 2nd, 2016, another certified question from a federal district court. The question presented was, does Ohio follow the at-the-well rule, permitting deduction of post-production costs, or does it follow some version of the marketable product rule, limiting the deduction of post-production costs under certain circumstances? Well, turns out the Ohio Supreme Court sort of punted on this one. Said under Ohio law, an oil and gas lease is a contract subject to the traditional rules of contract construction. Because the rights and remedies of the parties are controlled by the specific language of their lease agreement, we decline to answer the certified question and dismiss this cause of action in this case. So our court, the Ohio Supreme Court, told the federal district court, you have to look at the exact language, the specific language of the oil and gas lease. And based on that, if it's unambiguous, just apply what the lease says. If there is some ambiguity, you can look at what's happened over the term of the lease. In this case, some of the leases were 20, 30, 40 years old, and the court said, hey, the Ohio Supreme Court said if there's some question, look at extrinsic evidence. What have the parties done throughout the course of their relationship? And we, the Ohio Supreme Court, we don't have that evidence in front of us, so we can't decide it. So federal court, we're kicking it back to you, you decide. Interestingly, there were 2 dissents to the dismissal of the certified question. One was Justice Pfeiffer, who said essentially he thinks that Ohio should follow the marketable product rule. And then Justice O'Neill also dissented and reached the exact opposite conclusion and said, no, I think this is an at-the-well rule state, at least with the leases presented in front of us. So there's not much very helpful coming out of that, being a dismissal and 2 dissents, each by 1 justice, and each reaching an opposite conclusion. So we'll see if another case comes up the pike or down the pike that puts us back in front of the court and gives us some guidance going forward. But right now, we really don't have any good guidance, at least nothing from the Ohio Supreme Court. So moving on to some lease validity cases. These continue. I think all of us know there's just been an immense number of cases filed over the years of lessors, landowners seeking to find reasons to challenge leases, to have leases declared expired, terminated, canceled. It's slowing down a little bit, but there's still some new law coming out that's really pretty helpful in defending against these kinds of cases. And you'll see a bunch of these cases come out of the 7th District, and I'm just going to walk through them sort of in reverse order from the most recent key case working back. First one I want to talk about is Potts v. Unglaciated Industries, just decided December 30th of last year. It was an old lease, and the lessors asserted that the lessee had to provide evidence of production throughout the entire 112-year secondary term of the lease to counter their argument that the lease had expired for failure to produce in paying quantities. So look, you need to show for the entire 112 years that you've produced in paying quantities. The court disagreed and said, no, that's what the statute of limitations is for. You don't have to look back the entire 112 years. The statute of limitations for written contracts used to be 15 years, now it's 8 years. And of course, that's the relevant period. That's all that applies. You don't have to go back throughout perpetuity because what evidence can you find from 100 years ago that's going to really provide either side any evidence to prove their case. The language of the Court of Appeals was that where a lease is in production, a prior period of alleged non-production or insufficient production is a situation encompassed in the legislative mandate to apply the statute of limitations for a written contract. And then it quotes from the portion of the Ohio Revised Code specifically applicable to oil and gas leases, talking about an action alleging a breach with respect to any other issue that the lease or license involves. And that's the Ohio Revised Code section that has the 4-year statute of limitations for royalties, and then goes on to say anything else for breach or any other issue beyond royalties, you look to the written contract statute. And so it used to be 15 years, now it's 8. In this case, the court said because of the various the timeliness issues in the case, the 15-year applied. And they said even though the trial court might have looked at the 21-year quiet title period, still doesn't matter. There's still an applicable statute of limitations, and it should be 15 or 8 going forward. So a pretty important case, because I think there's been many cases out there where people are raising ancient gaps in production and saying, hey, you had a gap of production 30, 40 years ago. Yeah, maybe I'm just noticing it now and I'm just suing you now, but this lease should be terminated. Court says no. That's not the right criteria. We can only go back during this defined look-back period. Next case you want to look at, also 7th District, also December of last year, busy month for the court out there. Another production and paying quantities case. The landowner sought to have the lease declared expired or canceled. And the unique situation in this case was the well shared a common meter with anywhere from 2 to 5 other wells in the past. And the lessee wanted to use that evidence of the common metering to show that there was production. There's some evidence of how the division was made. There was maybe some not so helpful evidence that some years might have been a bit of a guesstimate. The trial court said, no, that evidence isn't sufficient. The court held that production was an estimate at best, and it doesn't satisfy your burden to show that there was production, at least to counter the evidence that there was no production in paying quantities. That evidence doesn't save you. It's just an estimate. The argument from the lessee was, hey, look, this common metering, this is an accepted practice. Why did the trial court refuse to accept this evidence? The trial court got it wrong, and the Court of Appeals said, well, no. So just because this practice of common metering is accepted by some oil and gas companies, that doesn't mean the trial court had to accept it in this case as a valid means of measuring production for purposes of whether a well is producing paying quantities of gas. So something to watch out for if you do have wells out there with common metering. This is something to be aware of, that where there was no good record keeping of what the individual wells had produced, no way to distinguish between what the different wells had produced. We've got at least one trial court and an appellate court saying that's not enough to save the lease. Moving on, another December case from the 7th District, Haverhill Glen v. Eric Petroleum. This one's a sort of limited issue of a force majeure clause. We had a lease that was still in its primary term, went out to get the well drilled during the primary term, and the landowner, as the court noted, the lessee's representatives were denied access. They were cursed at, lunged at, and physically threatened. And the court actually included some of the language of the threats of the landowner against the representative of the oil and gas company trying to get on the property. The lessee declared force majeure under the lease, said, hey, you're not letting us on the property, we can't do our survey, we can't stake the well site. The lease can't expire under its own terms for not going into the secondary term when you won't let me on the property to drill the well. And in this case, the Court of Appeals said, yeah, that's right. Trial court was correct in concluding the force majeure clause in the lease was triggered on these facts. This is precisely the situation that this lease provision was intended to cover. So when you get into situations where your lease has a force majeure clause, you're trying to get on the property, landowners preventing you from doing what you need to do, we've at least got some new case law out there saying, yeah, this is there to protect the oil and gas company, the lessee, from those situations where we're not allowed to get on the property. Moving on, we're going back a little bit now to June of last year, Burkhart Family Trust versus Antero Resources. So a little more of an evidentiary issue in this one, but something we may run into every now and then. Another production paying quantities, and the question was, as an initial matter, if you, the oil and gas company, are being sued for lack of production and paying quantities, who has the burden of proof? Who has to show what? And the trial court actually said, well, landowner, you don't really need to show anything, but oil and gas company, you have the burden of proof. You have to show that your wells are profitable during that period of time. Even the landowner can just say, we think there was no production in paying quantities. And that was appealed. The appellate court said, no, this is a question of civil procedure. It's not really substantive oil and gas law. If you're suing someone, you have the burden of proof to show what you're trying to achieve. So, in the court's words, the fact remains the lessor had the burden of proving by means of evidence that the wells that they admitted were producing do not produce in paying quantities. So again, a bit of an important issue out there for those of us who get into this litigation where landowners just sometimes make up allegations that there's no production in paying quantities. And here the court sort of laid down the law and made clear, no, there has to be more than just a bare allegation. There has to be some evidence. And the burden doesn't shift to the oil and gas company to prove that there was production in paying quantities unless and until the landowner is the one bringing the suit can provide some evidence that there was no production in paying quantities. Another June case, 7th District, in June of last year, RHDK Oil and Gas versus Dye. This one mostly reiterated a point of law that we believed was pretty accepted in Ohio, but reaffirms that in the 7th District. There were some prior periods of non-production, but none of them exceeded 6 months. They were within the statute of limitations period. You know, there was uncontroverted evidence that there were these periods of 4, 5, 6 months, over three separate periods where there was non-production, and the landowner was relying on that, saying, look, you had 3 periods of non-production, habendum clause, look at the habendum clause, lease is expired. Court said no. Absent a finding of unreasonableness, a 6-month cessation period is considered temporary, does not terminate a lease. Just again, drawing a bit of a bright line, if you do have 6-month periods of non-production for whatever reason, often, and the court talked about here, many of these periods were during the winter, there were some maintenance issues, it took some time to get out there to do the repair work. That's all reasonable. There has to be, the only way to get around this is if there is some sort of unreasonableness factor. The court didn't give any real examples of that, but again, giving us a bit of a bright line that 6-month cessation periods, even if there's multiple periods, those aren't going to cause termination of a lease. And now, one we're watching here, this case came out of the 4th District. It was actually last year when Tim McGrainer gave this report, he talked about this case as well. But I'm bringing it back up because the first case I talked about, Potts, that said there is a statute of limitations. You don't need to look back forever or the landowner can't rely on an ancient gap in production to establish termination. This court, in this case, went the other way. There was an alleged lack of production from 1977 to 1981, but continuous production since at least 1992, uncontroverted evidence. The Court of Appeals said affirmative defenses of laches and statute of limitations don't apply. It said 1981, the lease had automatically terminated. We don't care that the landowner accepted royalties from 1992 to present day. We don't care there's been production from 1992 to present day, and maybe even between 81 and 92. We just don't care. The lease is gone. It doesn't matter that any of those things happened. It doesn't matter that the landowner waited decades to bring the lawsuit. The lease is terminated. That was appealed to the Ohio Supreme Court, which actually initially had declined to take jurisdiction, and on reconsideration accepted jurisdiction, but only on one proposition of law. The proposition of law was the landowner should be stopped from terminating an oil and gas lease by the acceptance of benefits. Oral argument in that case is scheduled for less than 2 months, May 2nd, 2017. As you can imagine, everybody's also arguing in their briefs to the court. You know, that's the primary question, but court, you can also look at the statute of limitations thing, even though you haven't specifically picked it up as a proposition of law. And a couple of the justices actually dissented and said we should have accepted both questions, both this estoppel by continuing to accept benefits for decades in this case, or that there should be a defined look-back period. So we'll see what the Ohio Supreme Court says. If the oral argument's made too, hopefully we'll have a decision sometime this year, and by the time one of us is up here next year giving this report, we'll hopefully have some good news from our perspective from the oil and gas industry's perspective, how we have to, or what evidence can establish a termination of a lease. So those are the lease validity cases. I want to move on to some of the newer cases that are coming up, cases that are a little bit newer to Ohio courts. These are some of the pipeline cases out there. The first ones that came up was regarding the ability to appropriate property for pipelines. Kinder Morgan versus Simonson. This came out of the 5th District on June 27th of last year. Kinder Morgan, and it's for the Utopia pipeline. Kinder Morgan sought access to Simonson's property to conduct surveys, inspections, and examinations. And the trial court agreed that Kinder Morgan should be able to get on the property, entered an injunction saying, Simonson, you cannot interfere with Kinder Morgan's right to enter the property and conduct surveys. As you can, as you can imagine, that was appealed. And there were 2 holdings from the appellate court that are of import here. First is the trial court did not make an error in finding that the term petroleum is used in the statute, includes natural gas liquids, ethane, and propane. That's one of the arguments. Landowners said, hey, that's not propane. They don't get to follow the appropriation statutes because natural gas liquids don't fall under that. And the court said no. Did a survey of the law, how the term petroleum is used in various statutes, administrative code sections, and so the trial court got it right. This includes ethane and propane. Second key issue that was disputed was whether the Utopia pipeline could be considered a common carrier. And the court, again, agreed with the trial court, said a common carrier, according from the statute, is one who undertakes to transport persons or property from place to place for hire and holds itself out to the public as ready and willing to serve the public indifferently. And then the court applied the facts and said, here we find that the evidence presented supports the trial court's finding that the Utopia pipeline is a common carrier pipeline, therefore allowing it to move forward under the appropriation statutes. In this case, however, because it was just an issue of getting out there to do surveys, the trial court had not yet reached, and the appellate court therefore took no position on the necessity and public use elements of the appropriation proceedings, left that for a later date. And that came up in a different case, moving from the 5th District back to our 7th District, Sunoco Pipeline v. Teeter, 7th District, September 29, 2016. This case went all the way through the appropriation proceeding, and the trial court granted Sunoco's petition for appropriation and complaint for condemnation, concluding in one of the holdings that propane and butane are petroleum, same as the 5th District held. But this one, as I said, got all the way through, said, look, everything applies, just public use, necessity, common carrier, it's all there. Court of Appeals affirmed that case, said, yeah, trial court, you got it right. Landowner, though, filed an emergency, or appealed to the Ohio Supreme Court and filed an emergency motion for a stay of execution of that judgment. In a bit of a surprise, the court granted that. Said yes, so that Sunoco, you can't get out there, you can't do anything. The Ohio Supreme Court stayed execution and required no bond. And there was actually a motion for reconsideration, saying there should be a significant bond required, and the court said no. What we said the first time, we meant no bond is required. That case is still pending as far as whether the court is going to accept jurisdiction over the actual appeal. The way the stay is written, if the court declines to accept jurisdiction, the stay will expire and Sunoco can move forward. But right now, that's one we're watching, at least as of last night when I checked the docket. There was no decision yet. The briefing looked to be complete for and against jurisdiction, but the court hadn't made a decision yet. So we'll see what happens there. So last are 2 sort of miscellaneous cases that don't fall into any of these other categories. The first one maybe isn't as important as the second. The second one's caused, I think, some significant discussion in the industry recently. So I'll go through the less controversial one first. So it's Barnes versus Reserve Energy, also 7th District, last June. This is one of the notarization cases. I'm sure many of us have run across lessors who have said, hey, my lease wasn't acknowledged properly, therefore it's invalid. There's really no lease here because you said I signed it, the notary said I signed it, I didn't really sign it. And we've got pretty good law now out of Ohio courts saying no, if there's no fraud, the lease is enforceable even if the acknowledgement is defective. And these folks keyed in on that fraud part and said, well, no, there was fraud here. The landman that came out told us that we'd lose our oil and gas to wells drilled on the neighboring land if we didn't sign the lease and the neighbor did. Therefore, the issue is whether that statement would support the fraud element that would kick them out of the rule that in the absence of fraud, the lease is valid. Well, the court disagreed. The court disagreed with the landowner. It said, no, it's long been held under Ohio law that a representation of law is an opinion and cannot form the basis of an action for fraud in the absence of a fiduciary relationship. And there is no fiduciary relationship between a landowner and a landman. Further, Ohio has recognized the rule of capture in the oil and gas lease context. Although it's been modified over the years by the various spacing requirements, that's still a law of Ohio. And this statement that the landman made about losing oil and gas to wells on neighboring land, that's essentially a statement of the rule of capture. It may not be perfect, it's sort of a statement of law, nevertheless, doesn't apply, lease is valid. So, good decision there. And now the most recent case that's come out, has been the source of some controversy, Dundix v. Eric Petroleum. 7th District, just decided just less than a month ago. This was a case where Dundix did some work for Eric Petroleum as a landman, found some leases, didn't get paid, or at least in the complaint that he filed, he said he didn't get paid for the work he did. Eric Petroleum moved to dismiss the case and said, wait a minute, Dundix, you weren't licensed as a real estate broker. I don't have to pay you under 473521. Went to a magistrate. Magistrate said, yeah, that's right. You were acting landman as a real estate broker. You didn't have a broker's license. You're not entitled to payment. That was the issue, 473521. Trial court agreed with the magistrate and said that, Dundix, you had to have a real estate broker's license to perform services as an independent landman. So that was unsurprisingly appealed. There's an amicus brief from the AAPL, and the appellate court, 7th District, has at this point affirmed the trial court. Took a broad reading of what a lease is, what an oil and gas lease is. Said whether described as a license, a lease, fee simple, determinable estate, or something else, any instrument affecting oil and gas necessarily affects the surface rights as well, and therefore falls under the definition of real estate in the licensing statutes. Thus, to engage in any of the activities alleged here for compensation, one must have a broker's license. And one of the arguments that the AAPL made, a little more forcefully than Dundix, was that, look, if you look at the licensing statute, all the training someone has to take or has to have to get their real estate broker's license, this doesn't really apply to oil and gas leases. It's discrimination in leasing and selling properties. No one's living in the oil and gas lease. This isn't the right, it shouldn't be applicable. And there's also a couple federal district court opinions that have come out in recent years that have gone both ways. We had one court say, well, that does fall within the broker's license statute. And we've had another court, federal district court, say, go the opposite direction. So it's a little unclear what the law was. And so the argument was also made that, let's look at the statute. Let's look at what courts have said and look at what's required. And this is, an oil and gas lease is different. Court said, no. So based on our conclusion, the Court of Appeals' conclusion that the statute was unambiguous, we decline to consider the legislative intent, the legislative history, public policy, or the consequences of our interpretation. So even though you've raised this issue of what this is going to do to the industry, essentially you're making all independent landmen go out and get real estate brokers' licenses, the consequences of our interpretation are irrelevant here. We think there's no ambiguity, notwithstanding the fact that two federal district courts have reached opposite conclusions. Right now, this is still within the period for appeal to the Ohio Supreme Court. We're keeping an eye on it to see what happens. Presumably, there will be an appeal, but we've still got a couple weeks left before that appeal has to be filed. But that's a pretty important case to the industry right now, and we'll keep an eye on it and see what happens. So it looks like I am just about out of time. That is the update of some of the key and notable cases from the Ohio courts this year affecting our industry. And I'd be happy to take any questions now. I also have copies of the handout available at the back of the room, and I think it also gets posted on the OOGA website. So I'll be over here if you have any questions, or I don't know how well we can hear in the room. right now, there's nothing to create that invalidity. No court has said the lease is invalid. All the court has said is, sorry, you don't get paid for your work. There's nothing right now out there that would lead a court to determine, or that would create really a basis for the argument that the lease is invalid. Most likely it's going to be royalties. There's some case law, other case law out there talking about free gas being something that you'd get anyway. Whether there was a lease or not, if the oil and gas are on your property and you own them, whether you received the free gas really is sort of irrelevant to the analysis, because either way you would have gotten that free. You were entitled to it either way. So it wasn't specifically raised in that raised in that case. That was more focused on the acceptance of all the royalties and, over the years, various delay rental payments, shut-in payments, things like that. Yeah, it seems to be more focused on actual payments, not on free gas. And there's actually another case that came out that was distinguished. I forget which case it was in. It was an Oxford oil case where someone was receiving free gas only from a lease, and I think it was the 7 districts said that's not enough to hold the lease. Anything else? All right, well, thank you very much.